Celebrating diversity. Challenger's commitment to providing a welcoming, respectful, and safe working environment free of harassment. At Challenger Geomatics, we celebrate our diverse working environment, from race to religion to ancestry to gender. At Challenger, we value our people. Our people are our greatest asset. At Challenger, we are committed to providing a welcoming, respectful, and safe working environment free of harassment. No matter who you are, where you work, you have the right to feel welcome, respected, and safe from your coworkers, subordinates, superiors, suppliers, and clients. In this presentation, we will take a closer look at what harassment is, where it can occur, and what our responsibilities are. Harassment occurs when an employee is subjected to unwelcome verbal or physical conduct because of race, religious beliefs, color, place of origin, sexual orientation, ancestry, mental or physical disability, marital or family status, source of income, and gender. Examples of harassment are verbal or physical abuse, threats, derogatory remarks, inappropriate or dirty jokes, innuendos, taunts. Challenger will not tolerate the display of pornographic, racist, or offensive signs or images, practical jokes that result in awkwardness or embarrassment, unwelcome invitations or requests, whether indirect or explicit. Your work environment is to be harassment-free at all times. Your work environment is defined as any physical or virtual place in which you are dealing with coworkers, subordinates, superiors, suppliers, or clients. Examples of work environment include your office workplace, the office parking lot, your place of work in the field, a client's office, inside your work truck, at an office party. Your work environment may also include the internet, email, and phone, regardless of whether the correspondence is during work hours or not. Gender diversity in the field is on the rise. Historically, work in the field was predominantly performed by men. Not so anymore, as more women are working outside the office and in the field. Perhaps in the days of old, the field may at times have been a place where locker talk, sexual jokes, and innuendos were deemed okay by some, with the misguided justification that the field guys are allowed to act differently than the office staff. Please know, this way of thinking has never been accepted by Challenger Geomatics. The same standards of professionalism and the same harassment-free work environment must be administered by all employees, regardless of whether your workplace is in the office or the field. Definition of sexual harassment. Sexual harassment, being discrimination on the grounds of gender, is a violation of the Alberta Human Rights, Citizenship, and Multiculturalism Act. Unwanted sexual advances, unwanted requests for sexual favors, and other unwanted verbal or physical conduct of a sexual nature constitute sexual harassment when submission to such conduct is made either explicitly or implicitly a term of or condition of an individual's employment, or submission to or rejection of such conduct by an individual affects the individual's employment. Let's take a closer look at sexual harassment by watching this video.
This video DVD presents an information session on sexual harassment. The goal is to raise participants' awareness of key issues related to sexual harassment. Learning objectives include understanding the definition of sexual harassment in the workplace, understanding the types of behavior that constitute sexual harassment, gaining insight into the responsibilities of employees, employers, and managers. What to do if you or someone within your organization are being sexually harassed. You may be thinking, why am I here? I already know what sexual harassment is, or this doesn't happen in my workplace. But you are here today to learn about the legal definition of sexual harassment, liability, and what you can do if you believe you are being sexually harassed. Remember, no workplace is immune to sexual harassment. It can occur in any workplace to any employee. It is important to know that sexual harassment is against the law. It is also prohibited by your employer's policy. In Canada, each province has its own human rights law that prohibits employment discrimination based on certain protected grounds. As well, the Federal Human Rights Act, which covers those people working under federal jurisdiction, prohibits employment discrimination based on grounds that are virtually identical to those in provincial human rights law. Those working under federal jurisdiction include the Federal Public Service, the Armed Forces, and federally regulated businesses such as banks, railways, airlines, and interprovincial transportation. All the various human rights laws in Canada, without exception, prohibit sexual harassment. In short, there is no workplace in Canada where sexual harassment is not against the law. Sexual harassment in the workplace can have significant and adverse impacts on both the employer and employees. It can negatively affect productivity, morale, absenteeism, and the general health and well-being of employees in the workplace. To some extent, every employee is responsible for ensuring a workplace free from harassment. There are different types of responsibility or liability. 1. Corporate liability. An employer may be responsible for harassment by supervisors, managers, workers, and agents of the employer, particularly if the employer knew or should have known about the harassment and did not take action to stop it. Once an employer is aware of harassment, it has an obligation to take immediate action. If the employer finds that allegations of harassment are substantiated, remedies should be implemented that include both a disciplinary and remedial component to ensure that the behavior stops and does not occur in the future. Employers and unions have an obligation to ensure that the working environment is free from sexual harassment or discrimination.
All employees, including supervisors and managers, are responsible for their own behavior and may be held personally liable if they sexually harass other employees or make inappropriate gender-related comments. Managers and supervisors are liable if they knew that harassment was occurring and did not take steps to stop it.
Employers and employees may also be held liable for incidents of sexual harassment that occur outside normal business hours or off-site, but are related to the workplace and impact employment. Example: a supervisor sexually propositions his administrative assistant in the parking lot after a staff holiday party, using texting, email, or other social media like Facebook to embarrass, insult, bully, or tarnish a coworker's reputation. Federally, the Canadian Labour Code provides the following definition of sexual harassment. Means any conduct, comment, gesture, or contact of a sexual nature. A. That is likely to cause offense or humiliation to any employee, or B. That might, on reasonable grounds, be perceived by that employee as placing a condition of a sexual nature on employment or on any opportunity for training or promotion. The following definition of harassment, taken from the Ontario Human Rights Code, is representative of how harassment is defined under Canadian law as engaging in a course of vexatious comment or conduct that is known or ought reasonably to be known to be unwelcome. As the Ontario Human Rights Commission's policy on preventing sexual and gender-based harassment points out, the reference to comment or conduct that is known or ought reasonably to be known to be unwelcome establishes a subjective and objective test for harassment. The subjective part is the harasser's own knowledge of how his or her behavior is being received. The objective component considers, from the point of view of a reasonable third party, how such behavior would generally be received. Determining the point of view of a reasonable third party must take into account the perspective of the person who is harassed. Harassment, sexual or otherwise, is any unwanted conduct, whether verbal or physical, that humiliates or offends you. Harassment can interfere with your ability to do your work and thus can result in serious consequences in the workplace. Sexual harassment in particular has been defined as unwelcome verbal or physical advances or suggestions of a sexual nature, any sexually explicit derogatory statement, any pattern of sexually discriminatory remarks made by someone in the workplace that is offensive or objectionable to the recipient, causes the recipient discomfort, creates a hostile atmosphere, or interferes with the recipient's job performance. In simpler terms, sexual harassment can include, but is not confined to, unwelcome sexual advances, requests for sexual favors, other verbal or physical harassment of a sexual nature, repeated and unwelcome comments. What is not sexual harassment? An occasional compliment, good-natured jokes and jesting where both parties find the conduct acceptable, office romance, where both parties enter into a voluntary relationship. It should be noted that this carries risk. What happens if the relationship sours? How will that affect the parties' ability to work together and the comfort level of their coworkers? Normal exercise of supervisory responsibilities including discipline or counseling.
Sexual harassment is about power, not about sex. It's an abuse of power. Although the majority of victims are women, a victim of sexual harassment can be anyone, male or female. In many instances of sexual harassment, there is a power imbalance. The victim may be in a subordinate position, much younger than the harasser, in their first job, financially dependent on the position, physically much smaller than the harasser.
Not all victims react the same way. A victim of harassment may exhibit the following behaviors in the workplace: feeling confused, degraded, angry, frustrated, and humiliated. Physical and emotional problems, withdrawal from coworkers, and absenteeism. When an individual is being harassed in the workplace, there can be negative effects on the entire workplace. Increased stress, lack of trust among employees and between employees and management, employees leaving for other work, decreased productivity, increased workload as a result of turnover. Who can be a harasser? The victim's supervisor, a supervisor in another area of the company, a coworker, someone outside the company, a client or supplier, a woman or a man, the same sex as the victim. Types of sexual harassment. Human rights law addresses different types of sexual harassment. Quid pro quo. Employers have an obligation to ensure that the working environment is free from sexual harassment or discrimination. A supervisor might say, "Sleep with me and you will get a raise. Don't, and you'll be fired." Typically, however, things are not so cut and dried. A sexual solicitation is often implied, and the reward or punishment only hinted at. Example: a supervisor talks to his young administrative assistant about his frigid wife. He implies that if he were sexually satisfied, it would benefit her and the office, implying that rewards would follow upon having sex with him. The second type of sexual harassment involves behavior or comments that create a poisoned work environment. This is a work environment where the behavior is so objectionable that it creates unequal terms or conditions of employment. A poisoned work environment can be created by the behavior or comments of any employee, coworker, supervisor, or manager. Comments not directed at an individual may still create a poisoned environment if that individual is a member of the targeted group. Example: every time Jill, a female worker at a production plant, crossed the floor, she was required to run the gauntlet. Male workers engaged in catcalls, commented about her body, whistled at her, and made crude sexual remarks. Things reached a point where Jill dreaded going into work. When she did, she often arrived jittery and upset. Normally a reliable worker, Jill began to make frequent errors in her work, and whereas before she rarely missed work, she now was frequently absent and would keep to herself while at work. In a performance review, Jill was told that management was concerned about the decline in her work and the apparent change in her demeanor. Jill, who had been keeping things to herself, finally told her supervisor the trouble she had been having and how it had affected her both at work and at home. In light of this, management decided that it was time for their workers on the floor to receive anti-harassment training.
In some cases, comments or conduct may not be salacious, but rather target an individual's gender based on stereotypes. This too is a form of sexual harassment and can create a hostile work environment.
Example, a supervisor says that women don't belong in the workplace, but should be home in the kitchen. Another jokes that women are only good for one thing. Stereotyping comments like these are demeaning and contribute to a poisoned atmosphere where women do not feel comfortable or welcome. Typically, when we think of sexual harassment, we think of females as victims and males as perpetrators. That doesn't mean, however, that males cannot be victims of sexual harassment. In fact, while rare, there is case law in both Canada and the United States where men have been victims. There have also been reported incidents of same-sex sexual harassment.
Examples of sexual harassment or inappropriate gender-related comments or conduct. Continual conversation of a sexual nature. Persistent and offensive jokes of a sexual or gender-specific nature. Suggestive or insulting sounds. Example, whistling or catcalls. Lewd gestures. Sexual comments about body shape, clothes, weight. Inquiries about a person's sex life or relationship with partner. Unnecessary physical contact, i.e. pinching, touching, patting, brushing up against another. Condescending or paternalistic treatment. Unsolicited personal or intimate gift giving. Repeated requests for dates.
Not everyone agrees on what behaviors constitute sexual harassment. Is one person's point of view more legitimate than another? No. Sexual harassment is often said to be in the eye of the beholder. Comment or conduct that is perfectly acceptable to one person may constitute harassment to another. These different perceptions arise out of different points of view. For example, a Muslim woman may find sexual discussion acutely embarrassing, while her coworkers may differ. However, the Muslim woman's perspective is just as reasonable and legitimate as any other, and if the behavior is not related to the performance of the job, then it is arguably sexual harassment and should cease. Remember, in establishing whether sexual harassment took place, proof of intent to harass is not required. Instead, the focus is on the impact of the behavior.
The Muslim woman's coworkers may not have intended to harass her. In fact, by engaging her in sexual discussions, they may have been trying to include her in the group and make her feel welcome. Instead, the behavior made her uncomfortable and was felt as sexual harassment. Behavior that is harmless or good-natured to one person may be derogatory and insulting to another. To some women, terms like darling, girls, or sweetheart are acceptable, while to others, these expressions are objectifying and demeaning. Continuing to ask a woman out or calling her sweetheart, despite her objection, is sexual harassment.
Context is essential in assessing any behavior. Consider this situation and whether you think it constitutes sexual harassment. An invitation from the boss for an after-work drink. Scenario 1. Offered to several long-term employees in the presence of others after an important contract is won. Scenario 2. Offered to a subordinate of the opposite sex behind closed doors during a performance appraisal. This example shows that each situation must be examined carefully, given its context and the points of view of the persons involved. If you were sexually harassed, remember that it's not your fault. Harassers are responsible for their own behavior. The harassment most likely won't stop if you ignore it. It may actually get worse.
A person who believes she or he is being sexually harassed can take a number of steps. They are progressive and include: tell the person to stop.
Anyone experiencing sexual harassment should advise the perpetrator that their behavior is unwelcome, offensive, and considered sexual harassment. If the harassment persists or the person feels uncomfortable approaching the perpetrator, he or she should speak to the person's supervisor. Where the person feels uncomfortable approaching the perpetrator, he or she should take the matter to his or her immediate supervisor. If the immediate supervisor is party to the harassment, then the person complaining should bring the matter to the next level of supervision. If you are a member of a bargaining unit, speak with a union representative. Most collective agreements include clauses dealing with sexual harassment and discrimination. As well, labor arbitrators have the authority to interpret and apply human rights legislation in their cases.
Make a complaint through your organization's internal harassment complaint resolution process. Many organizations have an internal complaint process whereby employees can make either a formal or informal complaint that will be investigated.
Ask yourself the following. 1. Would I want my behavior on the evening news? 2. Would I want my partner to know about what I'm doing or saying? 3. Is there equal power between me and the person I'm interacting with? 4. Would I want someone else to act this way toward my partner, my son or daughter? 5. Is there equal consent? 6. Is there mutual respect? We hope this session has provided you with more information about sexual harassment, including the adverse effect it can have on both the victim and the employer, your liability, and steps you can take if you believe you were being harassed. It is everyone's right to work in and responsibility to ensure an environment free from harassment and discrimination.
As seen in this video, sexual harassment can include such things as pinching or patting, rubbing or leering, dirty jokes, comments, suggestions, or innuendos of a sexual nature, pictures or pornographic material, requests or demands of a sexual nature. All harassment is offensive, and in many cases it intimidates others. It will not be tolerated within our company. What is your responsibility? To celebrate our diversity. You have the responsibility to treat your peers, your subordinates, your superiors, your suppliers, and your clients with dignity and respect, regardless of race, religious beliefs, color, place of origin, sexual orientation, gender, mental or physical disability, ancestry, marital status, family status, or source of income. If harassed, tell the harasser his or her behavior is unwelcome and ask him or her to stop. Keep a record of the incidents and report the problem to a member of management immediately. At Challenger Geomatics, we want everyone to feel welcome, respected, and safe, so that together we can celebrate our diversity.